Hello everyone. Today we conducted our first introductory class on Canadian professional responsibility. The class was conducted basically in multilingual. I am just uploading my today's class gist for all those persons who could not make it possible to attend the introductory class. First of all, let me introduce myself. My name is BK. I'm a postgraduate in science holding a law degree from India. I got my accreditation from NCA and presently I am a licensed barrister and solicitor with Law Society of Ontario and Law Society of British Columbia. I am also certified and accredited international trainer on project management. I practiced in corporate law, criminal law, and economic offense wings defense at High Court and various district courts in Delhi for about, say, 10 years. Today's class was basically about the Canadian professional responsibility, what the Canadian professional responsibility is, why it is to be studied, how it is to be studied, and what is the difference between a Canadian professional responsibility and our professional ethics back home in our country, how they are different from each other. What is the main motto of studying Canadian responsibility in Canada? Second is how the Canadian bars are functioning here, because the provincial bars are disciplining and conducting the rules and regulations for their members as per the province. Back home in India, we were having the bar council at the apex level, followed by the state bar councils, then independent bar associations, which were directly controlled by the respective state bar council and at the apex level by the bar council. It is not the case in Canada. Although here also FLSC has been formed, that is the Federal Law Society of Canada, but it is still in the process of formation to get all the provincial bar societies to come to a common form. Now, basic question which was raised in the class: what you will get from this course? From this course, you will get a brief notes which were prepared by me, and these will be sufficient to write the exam. Secondly, you will get a summary of articles as per the syllabus published by the NCA. You will get a case index. You will get a brief of the cases mentioned in the index. You will have sample questions, and at the end, when we will be holding last two classes, we will have exact on the spot sample examinations in mock atmosphere, so that you are fully prepared how you can write the exam in bar when you are writing the NCA exam. Now, how the paper comes in NCA? Mostly there is a long fact scenario having 4 to 5 questions with different marks, and a short question which is either yes, no, one-liner or fill in the blanks, say of 20 to 25 marks. And these marks are very solid, and if you just study the model code, you can have these marks. The passing percentage in NCA is 50%. So if you score anything above 50, you are clear. But NCA never gives you the number of marks you obtained in the particular exams. They simply give whether you have cleared the exam or you have to write again. So that is all. Secondly, how you should attempt the paper. There are different views on how you have to attempt the paper. Some says that it should be written in a descriptive form. Some say that it should be written in IREC form. Some say it should be written in the crack form. So my submission is, even if you are slow in typing, but you are clear on the concept, then you should write point-wise. And how these points are to be maintained? These points are to be maintained in the form of, say, start with whenever you are going to read a question, just identify what the question is asking about. What is the concept that this question is testing? What is the issue which that particular question is raising? If you are able to identify that particular concept or issue, you are, say, 20% gone. Gone means you secure 20%. Then you have to identify which model code is related to this particular issue. Just mention the name of the number of the model code, and then follow it by the application of that model code to that particular relative issue, and given solid explanation. It may be in brief, or you can extend it depending upon the time availability. This should be followed by the number of cases which are related to that particular issue. If you are able to mention the case law as well as a brief about the case, you will get additional marks. Then there are 10 to 12 articles in your NCA syllabus. This article may be related to your question issue. You mention the article and relate that particular topic which the article is mentioning about this issue, and you will get additional marks. So if you identify the issue, number one, if you apply the relative rule of model code, that is the second, you are applying it and mentioning the relative case, third, and if you are mentioning the relative article, it is the fourth, and lastly, what the conclusion you are drawing from your above submissions gives you the complete answer. And with this complete answer, you are sure to get it clear. Now, once you have done it, you have to maintain you are doing the question, but what you should look for? The best and the only thing you have to look for is the time management. Time management is a must while writing a NCA exam. So what is the time management? Time management is, you have got 3 hours to write the exam. 3 hours means 180 minutes. 180 minutes means you have got 1.8 minute for 1 mark. If the question is of 30 marks, then you have got 1.8 multiplied by 30, it is equal to 54. So you have 54 minutes. If the question is of 10 marks, you have got 1.8 multiplied by 10, 18 minutes. This calculation should always be in your mind. Never jump over this. Otherwise, say if the question is of 30 marks and you are well versed that particular fact scenario, and you go on writing it, and you consume, say, 2 hours. So 120 minutes gone. How many marks you have done? You have done only 30 marks. Even if the examiner is agreeing with you on all the points, he will give you 24 or 25 marks, not more than that. Then what about the rest of the 70 marks for which you have now got only 60 minutes? So it is better to write within the particular time. Once that time is over, you should try to conclude it as soon as possible. So the best thing is time management. Number two, make point-wise reply to the question and get it clear. So that is all for the exam preparation, how you are going to write, what you have to write, in what way you should write, how you should manage the time. So if you have any question on this, you can just send a WhatsApp message to me, either on the group or even on my personal number. My number is 604-445-4071. I repeat, 604-445-4071. In today's introductory class, I discussed mainly the first three chapters. What were they? They were the professions, professionalism, regulation of lawyers, and the legal profession. Before going to professions, professionalism, regulations, the first thing what you have to do is you have to get through the model of code of conduct. What is model code of conduct? This model of code of conduct is the model code where the rules have been framed by the Law Society, FLSC. These model codes are to be got printed and kept with you while you are writing your exam. Without this model code, I won't recommend anyone to write the exam, because if you go into the exam without model code on your side, God forbid, it will be not possible to clear the exam. So whenever you are going to write the exam, have the printed model code, and in addition to the printed model code, you should have the index of model code on your side, so that you can check the numbers, what the particular rule the question is asking, so that you can mention it and get the required marks. Okay, so model code. What is this model code? The model code has got 7 chapters, and you will be surprised to note that the main 4 chapters, which are the 3rd, 5th, 6th and 7th, these 4 chapters constitute about 90% of the model code, and these 4 chapters are related to relationships only. Relationship with the client, relationship with the court, relationship with the students, your fellow lawyers, and relationship towards the society as a general. As regards the rest of the 3 chapters, first chapter is on definitions. Who is the lawyer? Who is the client? What is the profession? What is the professionalism? What is the ethics? And what is the second chapter? Second chapter is about your duties. And the 4th chapter is how you have to make your services available to the client and to the society. How you can market, how you can put your advertisements, how you should engage your clients. 4 chapters on that. And when you are going through model code, you will come to know that out of say about 22 pages, 102 pages are on the relationships only. Rest either marketing or definitions or duties, they only constitute 16 to 18 or 20 pages. So what is the most important? How you maintain your relationship with the client, public, court, and your fellow lawyers. Now, the first chapter is about the legal profession and the professionalism. For this profession, there are four main ideals essential for the legal profession. First is the legal profession should have a sophisticated structure of organization, a formal learning process, the spirit of public service, and these three makes the fourth one, which is the self-regulation. What is self-regulation? Self-regulation refers to the control, direction, or self-governance of a group by rules and regulations that are determined by the members themselves. The characteristic of self-regulation includes, number one, the presence of an autonomous governing body for the purpose of regulating conduct. Second, a specialized field of knowledge acquired through an extensive period of formal education and practical training. And third, the restriction of admission into the profession only for those who have demonstrated competence through education and practical training. So, self-regulation regulates. Who is going to self-regulate? Lawyers themselves. And lawyers themselves regulate through the law society. How the law society regulates? Law society can regulate at entry level before licensing them, and secondly, after, if they have been licensed, how they are conducting. So conduct of the lawyer and at entry level. At both the levels, the law societies regulate the client. And now, if we think self-regulation is there, law society is going to regulate, and if we get a question in the exam which is related to this, we have to mention the model code number and now the cases. For this, we can mention the case of Trinity Western University versus Law Society of British Columbia, or Attorney General Canada versus Law Society of British Columbia, or Law Society of Manitoba versus Savino. We discussed these cases in the class which was held today, and I will provide the basic index and a brief of these cases to my group members who join the regular classes, so that in case they get a question in the exam, they can write accordingly. Now, how the law society regulates at entry level? This comes how you can get a admission to the law society. For the admission to law society, what is the prerequisite? Prerequisite is, number one, you should have proper legal education. You have that much knowledge that you can clear the law society's exam. And second, the most important one, and this is the good character. If you don't possess a good character and you have all the education, you are excellent, you have cleared the law society's exams, even then law society may refuse to admit you as a licensed lawyer. Why? They will say that you don't possess a good character. And the relevant cases are Pereira versus Law Society of Upper Canada, Law Society of Upper Canada versus Burgess, Adams versus Law Society of Alberta, Law Society of Upper Canada versus Hunter, and so on. Again, the index and details or brief of these cases will be provided to the paid members. Now, Supreme Court of Canada, in case of Law Society of Upper Canada versus Bowman in 2011, mentioned 5 factors, which they said these are the key factors in determining the good character. What are these 5 factors? The first is the nature and duration of the misconduct. Second is whether the applicant is remorseful. Third is what rehabilitative efforts, if any, have been taken and the success of such efforts. Fourth one is the applicant's conduct since the proven misconduct. And the fifth one is the passage of time since the misconduct. These 5 factors determine whether the candidate is possessing a good character at the time of hearing or not. So this will decide his admission to the law society. So what are the ways, right? Once you are a lawyer, what are the ways that law society can regulate you? So law society can regulate you as per their rules. Who frames the rule? These rules are framed by provincial and territorial law societies, Federation of Law Society of Canada, or primary legislation, which is the Model Code of Professional Conduct. Now, what is professional misconduct? Law society can discipline you. And how they can discipline you? They can discipline you on the basis of your professional misconduct. And this professional misconduct may be by your disgraceful or dishonorable conduct in the society towards a client or towards your fellow lawyers, or conduct in unbecoming. This conduct in unbecoming is usually refers to the personal or private conduct of a lawyer, which may give rise to professional discipline. And this was best referred to in the case of Law Society of British Columbia versus Zabar, 1980, where the advertising was termed to be a cause of conduct unbecoming. So if you are doing any professional misconduct or conduct unbecoming, you can be disciplined by the law society. Now, when you can serve the client, or on what other basis the law society can control your conduct, and that is the competence. And what is competence? Competence is the legal knowledge, practical skill, attributes and values which you have gained through either your education, through your experience, or through your training and courses. And this competence was best quoted in case of Central Trust Company versus Refuse, 1986. If we go through the Model Code of Conduct, Rule 3.1-1, which states that who is a competent lawyer? A competent lawyer is a lawyer who has and applies the relevant knowledge, skills, and attributes in a manner appropriate to each matter undertaken on behalf of a client and the nature and terms of the lawyer's engagement. Again, the Rule 5.1-5 says a lawyer must be courteous and civil and act in good faith and to the tribunal and all persons with whom the lawyer has dealing. So if you are not feeling yourself competent, don't accept the case which is coming to you. So be competent, then only act. Otherwise, you may be regulated by the law society. Next is lawyer should be ethical. What is this ethical? Word ethics is derived from a Greek word ethos. It means way of living. Ethics are the moral principles that govern a person's behavior or conduct in the legal profession. Ethic covers integrity, moral principles, honesty, right, fairness, responsibility, conscience, choice, honor, and value. But this ethics doesn't mean that you will follow these ethics at the cost of your client. You have to follow the ethics keeping your client's interest at topmost priority. And this was decided in the case of Spalding versus Zimmerman 1962, where the court clearly said that defendants are not responsible for disclosing information which the client means the here plaintiff has failed to detect, and it does not means that the defendant's lawyer failed to observe the integrity. So you have to follow the ethics, you have to be of a good integrity, but that doesn't mean that you will do it at the cost of your client. Now, ethics, what are the sources of ethical conduct? The sources of ethical conduct are case laws and legislations, rules of professional conduct, that is model code of conduct, law society's disciplinary decisions, and judgments and issues which are not covered under model code of conduct. With this ethics, you have to also be loyal to your client. Loyalty means it is the value associated with the legal practice, and you should be always loyal to your client. Here also comes the loyalty. In the loyalty comes the your conflict of interest. If there is a conflict of interest, you cannot be loyal to your client. Your loyalty compromises when either your own interest or your any other client's interest is clashing with your client's interest. And this was very well discussed in the case of R versus Neil of 2002, where it is said that the duty of loyalty is intertwined with the fiduciary nature of the lawyer-client relationship, and it affects the jealous representation. Now, here also you can see about the article which is in your syllabus also, and that is article of Travers C.W. Farrow, which is Sustainable Professionalism, and the article is of 2008. Now, next topic comes is, we have covered the professions. Now, next topic is professionalism. What is professionalism? Professionalism may be traditional, or professional may be otherwise or say non-traditional. The traditional professionalism is keeping the client's interest on the top and being morally detached. Such persons don't require to see what the others are getting or how they are affected. They only see about their client's interest. So next one is your non-traditional, which clear means that besides seeing the client's interest, you are also concerned about the interests of others, yourself, your opposing lawyer, court, justice, or public interest. So here the client's interest is also taken care of, but it is not taken care of at the cost of any of the others' interest. Now, the article which we just called, that article shows a third aspect, which is the sustainable professionalism, which is mostly followed nowadays. Now, a lawyer who is functioning, how the law society is going to regulate him, how the law society can see that whether the particular law is professional or not, how the law society can see that that particular lawyer is flouting any norms or acting incompetently or misconducting or unbecoming. And when the law society receives any complaint, there are three stages at which the law society investigates, conducts hearing, and penalize. So the first stage is the complaint or investigative stage. At this stage, the complaint is received, investigation is done, and in this investigation, if it is found that the complaint is baseless or it has not got substance, then the complaint is closed and nothing is done. But if at the investigation stage it is found that something is there, then it is moved to the hearing stage where the hearing is conducted. The lawyer is given a chance to present his case, and at this stage, if it is found that lawyer cannot provide sufficient evidence or sufficient submissions for the issue raised in complaint, then it is recommended for penalty or sanction. Once the penalty or sanction is accorded, the lawyer is bound to mention it on his records, on his portfolio, and it is entered into his records. If the lawyer has been charged and has been penalized, he has the option to go to the court to have a review of the law society's action. And this review is always on a reasonable basis, whether that particular decision taken by the law society is reasonable or not. In addition to the law societies, legal profession is also regulated by courts and also by the voluntary membership. The unauthorized practice of law, who will take care of that? It is also regulated by the law societies. If anybody is found to practice unauthorizedly law, the law society can proceed against that particular person. Now, with this, the profession and professionalism is over. Now we move to the lawyer-client relationship. The lawyer-client relationship has basically three stages. The first stage is the formation of the lawyer-client relationship. How it is done? Whenever there is a first point of contact between the lawyer and the client, the relationship is established. And once that relationship is established, the lawyer is bound to maintain a particular record to check any conflict of interest in the future. Second is, what are the obligations and the competence of quality of service? And lastly, termination of the lawyer-client relationship. Formation we have discussed. Formation is even done when the particular party reasonably concludes that the lawyer has agreed to render legal service. Whether the retainer has been signed or not, that is immaterial. But if the client has in mind that I have discussed with the lawyer and he is ready to serve for me, then too the relationship is established. What are the obligations of the lawyer? Some of the obligations are: lawyers must not advertise using means that are false or fabricated or they are misleading. Lawyer must not advertise that amount to coercion, duress or harassment. Lawyer must not take advantage of a person who is vulnerable or who has suffered a traumatic experience and has not yet recovered. Or lawyer must not otherwise bring the profession or the administration of justice into disrepute. If a lawyer is engaged in another profession or business, he must not allow those interests to jeopardize the lawyer's professional integrity. independence, or competence. So these are the obligations. In addition to these obligations, a lawyer should provide pro bono services or reduce or waive a fee when there is a hardship or poverty that would deprive a client of adequate legal advice or representation. This is the moral responsibility and obligation on the lawyer. Now comes when the lawyer should market his services reasonably and should not take undue advantage. And this was referred in the case of Law Society of Saskatchewan versus Merchant, where the lawyer firms sought inappropriate solicitation and marketing. This firm was punished, and the group actually wrote letters to the survivors of the residential schools to help them in getting the proper compensation. So the Law Society found that their act was unbecoming. Now, if you are a lawyer and you have been employed by a organization or you have been hired by your organization and you found that that particular organization is working against the law or something illegal thing is going on there, then what should you do? You should immediately inform or advise the person who is giving you instruction. If he is not listening, then to the chief legal officer of that particular organization, and then the next one, the chief executive officer, the board of directors. And if none of them listens, then if you are employed by that particular organization, resign immediately. But if you have been hired by that particular organization, withdraw from representing that organization. And these two are the must. You have to do it. And this has been mentioned in the Model Code 3.2-8. And if you don't do it, then you will be in the Law Society's radar and you will may be punished. Similarly, if the case is over or you have been discharged or you have been terminated, then Rule 3.7-9 says that you must notify the client in writing and return all property to the client and settle all accounts. Now, there is a basic question. If a client comes to you and says that I have been fed up with such and such lawyer and I don't want to continue with him, you just take my case. So the Rule 3.7-10 says you cannot act for a client until that client has satisfied that the former lawyer has withdrawn or has been discharged by that particular client. So how you can terminate your services or how you can refuse to act for the particular client. You may refuse to act for a client if there is a conflict of interest, or you lack competence in the matter, or there is a continuing retainer with a previous lawyer, or the lawyer has the potential to be a witness in that particular case, or there is an illegal purpose. These are the 5 major points where you may refuse to act for the client or you may withdraw from acting for a client. Now, what is the withdrawal? You should withdraw, or a lawyer may withdraw. Why? When he may withdraw? If there is a serious loss of confidence between the lawyer and the client. In some circumstances, the courts may have to approve a withdrawal of the counsel. A request will be denied if it would seriously harm the administration of justice, as was discussed in the case of R versus Cunningham, where the counsel seeks untimely withdrawal for non-payment of fees. The court must weigh the relevant factors and determine whether the counsel should be allowed to withdraw or not, And whenever there is a serious harm to the administration of justice, the court will not allow the lawyer to withdraw. The rule 3.7-7 says that a lawyer must withdraw if they are discharged by a client, or a client is persistently instructing the lawyer to act contrary to the professional ethics, or a lawyer is not competent to continue handling a matter. So these are the 3 points where the lawyer must withdraw. And further, the rule 3.7-8 says, when a lawyer withdraws, the lawyer must try to minimize the expense and avoid prejudice to the client, and must reasonably facilitate the orderly transfer of the matter to the successor lawyer. Lawyer-client relationship may be terminated, and termination can be made explicitly or implicitly. The last but not the least, what is referral fee, and to whom a lawyer can pay a referral fee. A lawyer cannot pay referral fee to non-lawyers for the referring clients. And Rule 3.6-1 allows a lawyer to pay a referral fee provided the fee is reasonable and does not increase the total amount of the fee charged to the client. Second, the client is informed and gives consent. Then only the lawyer is allowed to pay the referral fee. Now, it is a famous quote that legal profession is not only for the sake of practicing law, but it is for the sake of practicing it well. So, if you are not competent, don't go for that particular case. So, this was all what we discussed in the class. As you were not able to attend the class, you may go through this video lecture, and if it appeals you, join my regular classes. These will be conducted on Sunday and Wednesday from 2 to 4 p.m. PST. Thank you. Thank you so much. Okay, bye.